Made locally in Bath. This is Radio Bath.
And this is Brave Business Conversation, and we're here with Greg Harris from Unividual Financial Planners. We are talking about planning your how you're going to plan out your inheritance and your estates so that you leave a peaceful set of accounts and an organized file so that the people that you leave behind, your loved ones, will not be all stressed out. What are the common mistakes that you see in your clients?
So, as with so many other subjects that we have spoken about previously, it's about having that conversation. Again, in the UK, we're so afraid of having those conversations about anything money related. We don't like talking about the M word. We're probably happier with talking about death than we are about money in some circumstances. So, definitely having the conversations. If you have got more complex circumstances about, maybe certain family members you want to give certain assets versus others to different members, then it's about just making sure that everyone understands why that is. And, very often people pass and the only document or only explanation they can give people is a will. And that's effectively a legal drafted document. So it's not always that has the facility to be able to say, well, look, I'm leaving this to you because of X, Y, and Z, and I'm leaving this to your brother, sister, whoever it may be, because of these reasons. So, we've got an opportunity while we're still alive, as cliche and ridiculous as it sounds, to have those conversations, people to be understand where they're going to be and what provisions are in place. And although inheritance tax can be so scary, there are some really simple ways of actually mitigating against that impact and allowing people to have the facilities to be able to pay for it. And if you have those provisions in place, tell your family about it, because they might be really worried, especially if you're well over those thresholds. People might be really worried that they aren't going to have the money to pay for that inheritance tax.
So as I said, 40%, if you're above the 325,000 threshold, and many people in this area would have a lot more than that. So you can leave things, without having to be equal. If you've got like 3 children, you don't have to split it 3 different ways.
You could give it all to your favourites.
You could give it all to your favourites.
Mum and Dad, if you're listening, thank you very much.
So children, if you're listening, wash the dishes tonight.
Yes.
Cook if you can. This is all going to benefit you in the end. So what are some of the things that we need to talk about? We need to talk about who we want to leave it to. Right? Is it just money and property? I would imagine that it would also mean things like, things that you have around the house.
Your personal
like
chattels. Absolutely.
This antique dresser, who gets it? Does that become a fighting point sometimes when you see clients that don't get that level of clarity from the people that pass by?
So, unfortunately, it's all down to the responsibility of the executor. So, basically, when you pass away and you've got a will in place, the executor becomes the legal owner of those assets temporarily and has to distribute the estate, make sure everything's settled, any debts, liabilities, taxes, etc. And then after that, they then have the responsibility of distributing those assets in line with whatever the will says. So, very often, and again, different people have different thoughts on this, but very often it's better to have a will that's quite broad and open to an element of interpretation, so that if things change, you're not having to update your will every couple of years. But what that effectively enables people to do is have a little bit of discretion with what assets go where. And if it is a split, and you've got a brother and sister, let's say, that are inheriting an estate, one could say, well, actually, I really want that painting that mum and dad left, so I'll have the painting, and then you can have the additional bit of cash that's sat there, or and come to some arrangement. So it doesn't have to be so set in stone that it causes arguments. But again, the clearer that will can be and that instruction can be, or that your family, are, then the better and easier the situation it becomes.
My grandmother left behind 10 children. She didn't have multitudes of money, but she had things like her diamond earrings, and this, and house, and everything like that. And because she didn't have a will, and thankfully all the siblings kind of just got along, they decided that everything was going to be split 10 ways, and then everybody's going to have a little piece of paper. If they want to donate their part to somebody else, they would write the name of the person on that piece of paper and how they want to split it. So everybody would have to turn in that piece of paper anonymously in this bowl, and everybody can read everybody's handwriting. But some people say, no, I'll keep it for myself because they need it. Some people, like my dad, I think he just gave it away to one of his sisters who would need it, and a couple of other brothers and sisters did the same. So it was really, really a beautiful process, and they're still very. But that's if you've got a very a very close-knit bunch of siblings.
Where everyone gets on.
Where everyone gets on. The complexity, I think, is also when divorces come into play.
Yeah.
And kids from this marriage and kids from that marriage and ex-wives and wives. That gets really complicated.
It really does. And if you are in that situation, then you absolutely need to have a will, and it needs to be kept up to date. You know, it's one of those things where it's so simple and straightforward to get done and in place. There's so many different people that will be able to help you get that in place. Solicitors, specific will writers. You can even get them online now. I would apply an element of caution if you've got slightly...
I was just going to say, you know, in the post office, there's the will kit.
Yes.
What's the difference?
So really, I would say that is a very entry-level facility. I mean, everyone should have a will.
Better than nothing.
Better than nothing. So if you're in a rush or you need to get it done fairly quickly or you don't have a huge amount of assets, then potentially that sort of facility can, you know, serve a purpose. But I would say as soon as you've got children, you know, if there's divorce sat there in the background or has happened historically, or you've got slightly more complex situations, then I would say, you know, go and speak to a professional to get it written properly. Like I said, that can be a solicitor, or it can be a specific will writing business. Just make sure they've got a good track record and get that done. You know, it's only a couple £100 normally for sort of basic mirror wills. So most people that are needing to draft one could and should really, I would say, make affordability purposes for that, you know, make that £100-200 available, because it's absolutely crucial.
And it's interesting what you said. It's you think about your will when you start having assets. So when you buy your first home, that's a thought, right?
Yeah.
Because you never can plan when you're going to die. You know, you never plan that. I mean, people hope they'll live until their old age, but many people don't. So it's an interesting topic. We'll be back with more after this. Right, we are talking about inheritance, leaving things behind, making sure people feel in peace when they're mourned for you rather than getting strange phone calls. So how do we get away with it? I mean, how do we mitigate it?
Legally mitigate, you mean? Yes. Not get away with it. Unbelievable.
Let's say unbelievable. What kind of radio station is this? Anyway, so how do we mitigate it? Let's say we've got millions and millions.
So look, the good news is that there are lots of genuinely legal ways of reducing that liability. One of the common ones that people often look at is gifting. You've got your gifting allowance. Each person's got about £3,000 a year where they can gift each year, and that then falls outside of the estate.
Sorry, it's £3,000 per child or per person?
Per person doing the gifting.
Oh, okay.
So you can do that every year, and that definitely falls outside of your estate for inheritance tax purposes. But there's another rule there which sits alongside regular gifting, and effectively an individual, if they can show a track record of regularly gifting to another individual, and that doesn't impact the person that's gifting, it doesn't impact their standard of living, and it's born out of natural income, etc., and a couple of other rules that sit there, but that then could potentially fall outside of the estate as well for inheritance tax purposes. But the easiest way, or one of the easiest ways, is actually to look at life assurance. Now, normally we associate life assurance with protecting against our mortgage or other liabilities that we may have. But what we can effectively do is work out what the potential inheritance tax is likely to be. And again, it's a little bit of a sensible and educated guess, because we obviously don't know, as we've said before, we don't know when people are going to die. But then what we do is we then work out, and let's say, right, there's £500,000 worth of inheritance tax due if we both pass away. We set up a life assurance plan that has an indefinite term, so it doesn't run to your 80, 90, it runs in line with the rest of your lifetime. And then what that would do is that would then be drafted in a way that's specifically written into trust. And again, apologies if I'm going too technical, but effectively that's written in trust, so therefore when it pays out, it sits outside of the estate for inheritance tax purposes. You leave it for the benefit of whoever's due to inherit your estate, and then effectively those people then have got the £500,000, so when HMRC come knocking for the money, they've got £500,000 and they can pay it straight out to HMRC.
So the insurance company has just paid your inheritance tax.
Yep. Exactly that. So then you're not having to sell properties, you're not having to sell assets or, you know, beloved antiques that have been in your family for generations. Or children. A bit of frowned upon these days. but
selling children?
Yeah.
Even the good ones.
Yes. Even the favourites. But yeah, so that is commonly, that was one of the first options we will look at with our clients, because again, it's completely legal. HMRC are getting paid, you're not having to lose your assets, and everyone's on the on
what kind of premiums do you pay for insurance?
So that is all based on how old you are and the value of the sum assured. But that then goes back to our initial point of if you can get that policy in place when you're in your 40s, 50s, providers, that's going to be really cheap to get in place. It's only life cover. It's when you then get into your 60s, 70s, and some providers will allow you to take out policies in your 80s, that's then when it becomes really, really costly. So again, it's still sometimes sensible to do so, but it's all about making sure you get those provisions in place nice and early on, and then you're not having to, literally sell body parts to then fund the premiums. It's all done in advance.
Yeah, those cards. Are you going to donate my organs? No, I'm going to sell them now,
Yes.
just so I can pay my inheritance tax. Yes. We talked about international assets. How does that work if you've got more than one country?
So really, really difficult because it does depend on where those other assets are. So in the UK, you will pay inheritance tax on your worldwide assets, so that should normally be the case that it's included. Now, there will be certain agreements between the UK government and other countries on double taxation, and it all takes into account your domicility, etc., where you were born, where you've resided. So quite a complex set of situations there, and I would say that if you are in that situation, you need to get advice, I would say sooner rather than later, because one, things change, so you need to make sure that you're meeting those rules as it stands now. But the sooner you know that actually you've got everything sorted is, you can then tell your family or whoever's inheriting those assets. Because if you don't know as the person that owns those assets in all these different countries, then pretty much can guarantee that your partner or your children, husband, wife, family, whoever it may be, will also not know because they don't own those assets abroad either.
Yeah. So if you have a couple, you would count their assets separately.
Separately, but then also have a look at the position on a joint basis as well. So separately, if they're planning on, let's say you've got a husband, your husband and wife, and wife,
they both have assets.
Both have assets in their own names, but also jointly. But then the first person that passed away is going to make gifts immediately to other family members other than their spouse. If that's what they're wanting to do, then you need to have a look at their position individually, to then work out what nil rate bands they've got, and then collectively on the transfer of those nil rate bands to make sure that on second death there isn't an additional inheritance tax liability on top of it.
Yeah. What about unmarried partners or civil partners, etc.? So, is that an automatic thing when the person passes away? Then the civil partner or the unmarried partner gets the.
So thankfully we've caught up with the times a little bit, and now the married couples will have the same rights as civil partners as well. So if you've got a legal civil partnership in place, then effectively you get those same rules as your more traditional sort of husband and wife would in sort of old and older. Yeah. It's if you're cohabiting and you don't have any kind of formal arrangement in place, marriage, civil partnership or anything like that then becomes more tricky, and then you're subject, if you did pass away, to the laws of intestacy. Now that definitely will put people to sleep on this afternoon. So it's not always the most favourable position, and where unfortunately you get couples or families or dynamics where you aren't going to go down the traditional marriage route, and fair play to people. But that effectively can cause more complex inheritance tax issues if you're not making sure that you've got a will in place. So I would suggest, if you are in a same-sex couple or you're in a relationship with someone that you're never planning on getting married or entering a civil partnership, definitely make sure that you've got a will in place that passes those assets to each other, if that's what you wish to do, because otherwise you could be subject to the laws of intestacy and you might not even speak to the family members that would be in receipt of those assets. So
yeah, and that's why I brought it up, because a lot of people say, we cohabit. That means after 2 years, I think that's the law in UK, you are kind of like a married couple.
Well, it's common law partners, isn't it? I think they call it,
Yeah, but no. Yeah, but no. There needs to be, and you're not a legal registered civil partner. You're not that. You are just cohabiting. Correct. Girlfriend, boyfriend. So if you do expect that the other person will get something, you do need to make some legal documents.
And as we've said, it's really not costly to do that.
Yeah.
You could get an entry-level will probably for £100 each, £150 each.
Yeah.
So it is worth that. People say, well, it's quite a lot of money. And sometimes when you're early on, it can be a bit of money for younger people that have just bought their first house or something like that.
Sure.
But it's the risk, for me, it's the risk of not having that in place is far greater than having a really straightforward will that goes, right, okay, if I pass away, everything goes to you, job done.
Yeah. Well, if you just cut out one drink or one coffee a day, right? Like out and about when you're having that coffee is like 3 pounds or something, then over the course of 30 days, you've had 90 pounds. So I think, maybe in three months, you'll get that will
And
sorted.
that's the saver in you talking, isn't it?
No.
Yes.
All that stuff that you don't need on eBay. That'll pay for your will.
What a fun thing to sell things on eBay for.
Yeah, I'm saving up to write a proper will. We'll be back with more easy talk about the D word after this.
Radio Bath.
And we are still with Brave Business Conversations. We are still talking about how to mitigate inheritance tax.
Yes.
Mitigate.
Yes.
Good word. What else? What else can we do?
So we've covered some of the more basic sort of solutions off. Now, very often with any kind of financial planning, it's not necessarily you have to do option 1, 2, 3 or 4 and you can only do those options. Very often we look at trying to produce a bit of a hybrid scenario, and one thing that you can look at is making use of AIM listed investments. So that can potentially qualify for what we call business property relief. So although you still own those assets, provided they hit certain rules, which we can chat about in just a second, those assets get 100% relief from inheritance tax. So you could have savings and investments that go alongside your property, pensions, etc., and they could be pushing you over the threshold. So what you would do is you would change what they are invested. You wouldn't necessarily change the tax wrappers, so it could stay in an ISA or stay in an investment account. But what you could effectively do is have the underlying investments within those tax wrappers, something slightly different, and then therefore have the business property relief qualifying investments, so that then after 2 years, those assets are outside of your estate. You still own them, you can still use them, but they're not included when we're looking at then inheritance tax liabilities later down the line.
Interesting. Okay. For more technical help, obviously it's like listening to all these ideas is helpful, but it could also be a bit overwhelming, right? Sometimes it's better, instead of getting ideas, is to talk to someone about it. This is what I have.
Yep.
This is, I'm sharing this because this is what's happened to me. I go to workshops, I listen to YouTube videos about how to, and I attend talks, and they're like, oh, great ideas. And then I start implementing it, and then I get lost in my own stuff.
Yeah.
And then what I realize, when somebody actually takes a look at what I have, they say, look, the only thing you need to know right now is this, or the only ideas I would apply to your situation is X, Y, Z instead of like 14 other things, right? So I think that's what you do as well for people who want to know more.
Absolutely. I think a good starting point is always to have a look online, and like you said, read up on things to see whether you do need help. I think as soon as you get to that point that you've just mentioned there, where actually there's more information than you need or you feel that you need, at that point, that's when our skill sets really come into play, because you're absolutely right. We can then filter that information and give you the information that you need to know that's relevant to your circumstances at that point in time, educate you on the different options if you need education, or if you want that education. That's a real crucial bit, because not everyone does. They just want to be told, this is what we need to do, crack on, I trust you, which is a lovely position to be in, but sometimes people need a bit more understanding there, and then we can then implement the options based on what your preferences are, and having, being in an informed position, but not so informed from Google searches that you really don't know what applies to you. Yeah, exactly.
And even if you don't take on financial planning services, having that initial talk, I think, for me, opens up that this is what I need, this is the articles I need to read, and because not everybody's ready to get someone to privately help them. But if you're just thinking about it, it's actually worth it. Yeah. It's actually worth it. At least to get some direction about where to look.
That's such a good word. I think what we try and do for people that, by their own admittance, we're happy to help anyone, but some people, as you've just described, they don't personally feel that they're quite ready for financial advice. And if we have that meeting with them and it's very clear that that's their intention, it's very much an hour of giving them information, showing them where they need to look for said information, and then at that point they can go off and then crack on with their own research. And then if it gets a little bit more complex down the line, then they know who to come and speak to.
Who to cry to.
Hopefully not. I've had a client cry me for a very long time, actually.
Yeah. Also, in business partnerships, make sure your contracts are drafted a certain way, because a lot of business partnership contracts don't come with a death clause.
No. You're absolutely right. So it's not a technical term. So people that are googling this,
death clause.
Yeah,
death clause. What number is that?
We often refer to it as sort of a business will. Now, no such legal document really exists before people start googling it and going mad that they haven't got one in place. But effectively, in exactly the same concept that you would have a will for your personal assets, you need some kind of documentation and some kind of sort of process in place where everyone involved is aware of what would happen should you pass away and leave business assets. More and more people now and families have got shares in family businesses or larger businesses. So understanding what happens should an individual, director, or shareholder pass away is so crucial and so important. And that's why you're absolutely right. Your shareholders agreement's really, really important. Your articles of association, everything that you would do to set up a business at that point, that's when you need to have that fairly morbid conversation. Okay, right, we've got the business, that's now trading. What do we do if something happens to someone? If they get ill, if they pass away, if they don't want to be part of the business anymore. Business owners work themselves into an early grave sometimes. So actually, they might want to step back.
That's inspiring.
Oh, I know, that was really bad, wasn't it?
You really made a few people lose their appetites there.
Get me off. It's time for me to go.
No, one more segment. The other thing is you can't assume that your children will take over you, and you can't the shareholders might not want your children. They might just want to release your shares, what is your shares going to be valued at? It's going to be at the time of your death. It's not what you promise or what you forecast it to be. It is at the time of your death. So how do we value shares? I don't see that enough in partnership agreements. How do we value shares when one of us decide not to be involved in the business, or when something happens and that person cannot function as normal or die or something? Yeah. Well, we'll be back with more of that happy subject after this. Final segment of Brave Business Conversation today with Unividual Greg Harris in the house, talking about death, inheritance tax, and all good things under the sun.
Well, that's a very nice way of putting it.
Yeah, I thought so.
Yeah, thank you.
So.
I mean, you've really fleshed out and made death quite an interesting subject there. I don't think I'm going to be able to live up to this.
You can't live up to it. It's death. Anyway, so we were talking about mitigating inheritance. I've got a question for you. Some people think they're really smart. They buy properties under their children's names. Just to say, it's not mine, it's my children. Is that smart? Is that it? That's pretty simple, isn't it?
It is. Credit to the government, though, as and when they made the legislation. But they got wise to that a fair old while ago. So, the idea of giving assets to family members, especially rental properties, that's such a common one where they go, right, okay, children are now adults, I'm going to put that in their name, but I'm still going to have the income coming through and I'm still going to benefit because I'm still alive, it's my asset. So, there are rules around being able to do that, certainly to avoid inheritance tax. So there's a sort of process called gifting with reservation. So you're effectively gifting the asset, but you're reserving the right and the benefit that you have there. So for that purpose, let's say it's a £400,000 property that you're renting out, that £400,000 property would still be included in your estate for inheritance tax purposes.
Even if it's under your kid's name because you took the rent.
Because you're still getting the benefit. Some people will, even if they don't have rental properties, they will gift their main residence, so the house they currently live in, to their children, but they're then still living in it. So the only way that would then fall outside of your estate if the children were paying effectively their parents open market value in rent while the parents still live in their own property. So as you can see, not very many families would want to do that because effectively...
Or actually the parents have to pay the children rent.
Correct,
for living in that house under their name.
Correct. Yeah. So it's one of those where not very many people particularly like doing that. But previously it's been a way in which people often think they can cheat the tax man.
They got smart people.
Yes.
It's been lovely having you. What can people do if they want to get in touch, get some advice? So they can call our main office. So our number's all over our website. Website is unividual.co.uk. Our office number is 0330 353 0150. And ask myself or one of the other advisors and we'll be happy to have an hour chat.